I am really pleased to welcome all of you to Constitution 101 for March, hosted by James Madison's Montpelier and the Robert H. Smith Center for the Constitution. Our guest this evening is Amanda Frost. She is the Anne Loeb Bronfman Distinguished Professor of Law and Government at American University, Washington College of Law. So she writes and teaches in the field of immigration and citizenship law, as well as US constitutional law. She has written for many of the nation's leading law journals. She's argued cases before the Supreme Court and lower federal courts, and she has had additional writing published in The Atlantic, Slate, The Washington Post, The New York Times, USA Today, and the LA Times. And for those of you who are Supreme Court fans, she also writes the academic roundup column for SCOTUS blog. So her recent book, You Are Not American, Citizenship Stripping from Dred Scott to the Dreamers, just came out at the end of last month. And so we are really, really thrilled that she's able to join us here today to chat about the issues of citizenship, which we have never had a Constitution 101 addressing before. So I'm really thrilled to welcome you, Dr. Frost. And if you'd like, you can certainly let everyone know where you're checking in from, because you definitely win the prize for furthest afield.
Sure, and thank you so much, Emily, for that lovely introduction. I should say my husband and I, who normally with our children live in Washington, D.C., had a lovely visit to James Madison's Montpelier a few years ago with an extraordinary tour, and we've been to all the local monuments and sites, and we both agreed it was by far the best in terms of the quality of the tour. So you were doing great work there. Right now, however, I am living in France with my family. We were here last year. I had a fellowship with the Collegium de Lyon to finish up my book, was in fact the goal, as well as to study French citizenship laws and related comparative law research. And then when the pandemic hit, we realized we should stay because schools remained open here and we have young children. So I'm here in France where it's 11 o'clock at night, but I'm wide awake to do this. So I'm going to share my screen and begin my talk. But a couple of thoughts or points I want to make first. One is that I'm a law professor, and for those of you who either went to law school or know something about it from movies like The Paper Chase, which actually isn't a good example, it tends to be an interactive classroom. And I much prefer to get questions and respond to comments or questions than to just lecture. Now, Zoom, of course, makes that a little more difficult. But the point is, I really want to urge you to use the Q&A function, even just to say, could you explain in more detail or follow up with more information, or I didn't understand X, Y, or Z. I'd really welcome that. So I just want to urge you to put those questions in the Q&A, and I will stop periodically to take those questions. So that's the first point. And the second point is I have a bunch of slides today. The first few slides are, I have words on them, which I try to avoid. I think it's better to avoid that. But just the first few have a lot of words. And then after that, it's almost all images. So I just wanted to sort of warn you, but also let you know you're going to see images of some of the people that I'm talking about. So now I'm going to share my slides, and let's see, start off with the presentation view. Hold on one second. There we go. Emily, is that looking okay? Great.
That looks great. Thank you.
Perfect. Okay, just like to make sure that I'm not talking endlessly about something no one can see. Can happen to you on Zoom. Okay, so we're going to start off today with a really brief overview of citizenship, a sort of constitutional 101 on citizenship with a focus on that. Then I'll talk about the book, which is focused on what I think is the hidden history of citizenship stripping in the United States. And the book is very much written for the non-academic. I was tired of talking just to law professors. And I wanted to tell stories about the people whose lives were affected by what I think is this unknown phenomenon, but nonetheless, very widespread phenomenon of citizenship stripping in the United States. And then I'm going to end by talking about what's happening today, because sadly, it's not only legal history, it's not only American history, it's also contemporary history, contemporary events. Our politics of today involve citizenship stripping. So I'll talk about that towards the end. So to begin, with just a few basic background pieces of information about citizenship. So what is a citizen? I put up the Black's Law Dictionary about being a member of a community and possessing the rights and privileges to be enjoyed by any person under the Constitution and government, and of course, having to do those corresponding duties that come with citizenship. And that's a good and important legal definition. And I do address legal citizenship in my book and the loss of the legal status of being a citizen. But I think all of us here also know that citizenship is more than just that legal definition. It's also about belonging and identity. And it's a way that a nation shapes its own identity by who it decides can be a citizen, and even more so, who it decides to take away citizenship from. And that's, in fact, a big part of the book, is the sense of identity and belonging and the attempt to shape and craft the meaning of American through revoking citizenship, and by the failures, by the fact that people fought back and kept their citizenship or expanded citizenship. I think that also says a lot about the United States as a country. So what about the rights of citizenship? What does it mean to be a citizen versus just a non-citizen living in the US? And we have many non-citizens living in the US. So it's an important category. So adult citizens, the most important right is that they can enter and remain in the United States with no legal barriers. Also important, of course, is the right to vote, with the exception of some states excluding felons. All people over 18 years old can vote. Citizens are also eligible to hold elective office, with the one limit there being only natural born citizens can be president. And I'm going to come back to that. Citizens have the right to serve on a jury, and indeed the obligation to do so. And also there's some employment restrictions on non-citizens in government, in particular. Federal and state government is often reserved just for citizens. And citizens have all the constitutional rights and protections that exist in the US Constitution. So non-citizens lack some of those rights, and many of those rights. They cannot vote. They're ineligible for most of those positions in elected government, or even as any position in government, even a fairly low-level state position, tends to be reserved for citizens. They can't serve on juries. Most important, there is no unconditional right to enter or remain in the United States. And President Trump demonstrated that clearly, if we had any doubts before that, in using his power over the entry into the United States to bar a number of people from coming in. They're ineligible for various employment. But importantly, non-citizens do have many of the constitutional rights and protections. And in fact, the Constitution, for the most part, doesn't refer to citizens. It refers to persons. And so being a non-citizen in the United States does not deprive one of all of the constitutional rights and protections. Some are more limited, but they still have many. So quickly, the rules for acquiring citizenship. I think most are probably familiar with birthright citizenship, known by its Latin term, jus soli, which means that if you're born on US soil, you're a citizen, period. Regardless of your parents' immigration status, regardless, of course, of race, religion, ethnicity. I say of course, but that was not an of course even 150 years ago or fewer, so we'll talk more about that. Arguably, birthright citizenship existed before 1868, but the 14th Amendment to the Constitution, which I will be talking about later in my talk, clearly created birthright citizenship, in case there was any doubt. Another way to become a citizen is through descent, through one's parents. So even if you're born abroad, if you have a US citizen parent, you can inherit citizenship with some limits and caveats. And then you can naturalize. And of course, it's a way that immigrants who come to the United States can become citizens, and they are supposed to be treated with the exact same rules and rights as the rest of us. Although in reality, that is not always true. And I will be talking about that as well. One last slide that I think is interesting for those who are, of course, interested in the Constitution, as all of you are. We tend to think of the right to vote and citizenship as coextensive. And today that's pretty much true, but that was not always the case. In colonial and early America, the right to vote was extended to non-citizens fairly regularly if they were white property owners. And of course, many citizens couldn't vote. Women, for example, people of color, people without property, indentured servants, large numbers of citizens couldn't vote. Today, we see they're almost completely overlapping. You can't vote if you're not a citizen almost ever. And almost all citizens can vote, with the exception of children and, in some states, felons. So that's where those two circles aren't perfectly coextensive. Last slide before I move into discussing the book, which is a couple of caveats that I think are important to keep in mind and that I always want to quickly make clear at the start of any talk about my book. Citizenship status does not confer always all available civil and political rights. We saw that Black Law Dictionary definition, it's supposed to. But we have to acknowledge that some people, while legally recognized as citizens, were citizens in name only. And of course, African Americans and women are two examples of those groups. Much less so today, obviously, but in the past, certainly. And as I've already mentioned, non-citizens also have important civil and political rights. Our Constitution begins, "We, the people of the United States," and I emphasize that word. It didn't talk about citizens, and in fact, citizenship was not mentioned hardly at all in the Constitution of 1787. And that indeed led to much of the conflict over citizenship that I'll describe in the book. All right, so that's my Citizenship 101, my intro to citizenship. If you have questions about that, I'm not going to stop quite yet, but please feel free to put them in the Q&A, and I'm happy to go back and explain in some more detail. So moving on to the book. So the book, You Are Not American, I had a couple of goals here. One goal was to tell this story of citizenship stripping from the perspective of those who lost their citizenship. So every chapter focuses on one or two, sometimes three people who either lost their citizenship or were threatened with loss of citizenship, often fought back, sometimes successfully. I don't want you to think this is just a grim history of deprivation of civil and political rights. It's not. And in fact, often people's fellow Americans fought with them to obtain their citizenship. But it's a surprisingly large number of people whose citizenship was threatened, millions, as I'll explain, different groups who either lost their citizenship temporarily or sometimes permanently, or had to fight to get it back. So that, I think, is surprising to many. I was surprised and shocked, which is part of why I wrote this book, when I learned of all the people who had lost their citizenship or who'd been threatened with that loss over the course of US history. And I wanted to tell their stories using their voices. So that's one goal. The other broader theme in the book, and this will come out in the talk, is that over the course of our history, we were a country initially that, of course, had racialized slavery, that engaged for many years until today even, but less so, in overt discrimination based on race, ethnicity, religion, ideological perspective. And over the years, there's been many successful battles to prevent, as a matter of law, that sort of discrimination. But we do allow differential treatment based on citizenship, as I've just explained, including things like the right to vote and serve in government, et cetera. And what's interesting is, as things like discrimination based on race became prohibited, citizenship stripping became more prevalent. And I see a direct connection there. Taking away citizenship became a proxy for the kind of discrimination that was illegal on other grounds. So that's another theme you'll see in this book as I talk about the contents of the book. All right, so now let's get started. As I said, the book's about stories. And so my talk today is going to be about the stories of the individuals that I profile in the book and about their personal history, which I think is very important to understanding what was going on, as well as their place in history. So I start with Dred and Harriet Scott, pictured here with their two daughters, Lizzie and Eliza. So, of course, I think many are familiar, but just to be sure, Dred Scott and his wife Harriet were slaves living in St. Louis, Missouri, and they filed a lawsuit in the late 1840s suing for their freedom. And they argued that they should be free along with their daughters, because under the rule of the time, and it was very well accepted in the courts, if a slave was taken into free territory by their owner, then they were free. Once free, always free had been the rule. And they were taken, as this map shows you, from Missouri up into the free territory, up into a fort, up into this square, pink square of free territory, and then taken back to St. Louis. And they said that made us free. So they filed their lawsuit. And that's what they cared about, their freedom. And Harriet Scott, Dred Scott gets all the press, but in fact, Harriet Scott was the motivator for this lawsuit, as a great book by Leah Vandervelde makes clear. And Dred Scott was older, he was about 20 years older than his wife. And frankly, he wasn't of much value. And in fact, his owner might've been willing to just let him go free at that point. But Harriet Scott was valuable. She was young. She had plenty of labor left in her, and she could reproduce. She had proven herself to be fertile. She'd had 4 children, 2 of them died, but she was valuable property, as were her 2 daughters. And the Scotts were terrified, and rightly so, that their owner would decide to sell the family and separate them through sale. And in fact, every week, Dred Scott and his wife and children passed by, they lived within a few blocks of the courthouse in St. Louis. This is a picture of that courthouse. And every week on that courthouse steps was a slave auction. And Dred Scott knew well how he could lose his family. In fact, his first wife had been sold away from him and he'd never seen her again. So they were terrified that this would happen. And simply by filing the lawsuit, they actually protected their family because they could not be sold while the lawsuit was ongoing. And they hid their daughters during this time. They had some freedom. Their owner was not living in the state, and they managed to put their daughters into hiding. And they only came out after all was said and done. So really, this lawsuit was about saving this family from being sold and separated. They didn't particularly care about citizenship, I don't think. And they probably didn't even think their lawsuit was about citizenship. And to the degree they thought about it, they probably thought, of course, we're citizens of the United States. We've lived here for our entire lives. But in fact, that was a question that was not clear when they brought their lawsuit. And in 1857, the Supreme Court was forced to address it because in order to be in federal court, they had to show first that they were citizens of the United States. So this is a picture of Chief Justice Taney, who wrote the opinion in this case in 1857. And he addressed both the citizenship question and the question of whether the Scots remained slaves. And the Scots lost on both counts. And he said, all Black people in the United States, whether free or slave, and there was 500,000 free Blacks as well as 4 million slaves, are not included and were not intended to be included under the word citizens in the Constitution of the United States, and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of the United States. So he was definitive on this. He said there's no way that they are citizens under the Constitution. Congress couldn't make them citizens. No state can make them citizens. And this was shocking and surprising. And when you read the newspaper commentary that came after, it was, of course, widely praised in the South and widely criticized in the North, this decision. But the citizenship portion of the decision was criticized as well, although it's received less attention throughout history than the larger and more explosive question about whether they remain slaves. But Justice Benjamin Curtis, in dissent, he walked through the arguments about why Chief Justice Taney was wrong. He pointed out that Blacks had voted to ratify the US Constitution in 1787. They'd been allowed to vote and they'd voted in favor. And so it was bizarre to think they were permitted to vote on a document that deprived them of citizenship. They were treated as citizens in some states in 1857. They rarely had the full rights of white people, even in the North, but in some states they could vote and exercise many of the rights of citizenship. The United States government had stated in official documents that Black sailors were US citizens, and that's to protect them from being taken by English. The English Navy tended to take aboard US citizens. And the US government said, no, even our Black sailors are citizens and you can't take them. It violates international law. So the US government had recognized Black people as citizens in some contexts. The Constitution really didn't address or define citizenship, the Constitution of 1787, which is quite surprising when you think about it. But it did mention that you had to be a natural born citizen to be president. And that suggests the fact that you had to be a natural born citizen to be president, that there was a group of people born in the United States automatically acquiring citizenship. And in fact, that the United States had wanted to create birthright citizenship, which had been the rule in England. And so it would seem the United States wanted to continue that tradition. And finally, the Declaration of Independence declared that all men are created equal, suggesting all are citizens. So what I find most interesting about that, Chief Justice Taney responded to that point, and he did so in a way that I find fascinating. It struck me as a very powerful moment in his opinion. He said, there's fine, the Declaration of Independence said all men are created equal. He said, but we can't imagine that the founders of our country meant to include Black people when they wrote that, because if they had, the conduct of the distinguished men who framed the Declaration of Independence, by their conduct, he means that many of them owned slaves, including James Madison, would have been utterly and flagrantly inconsistent with the principles they asserted. So, of course, Taney cites that as an example of why Black people can't be citizens. And in fact, he's trying to reconcile racialized slavery with these ideals that at that point we had nowhere near come close to living up to. But I read that and I see, of course, that hypocrisy of the founders, which I think we all recognize now, had to be resolved by getting rid of slavery. For Taney, it meant getting rid of citizenship for Black people. And of course, in the Civil War that closely followed and was precipitated in part by this decision, the answer reached was no, we have to, of course, get rid of slavery. So I want to stop here. I see there was a couple of questions in the chat. Let me see if I can get to them, or maybe Emily, I don't know if you.
Sure, I'm happy to.
I'm sorry, I'm not quickly seeing them, and I don't want to get rid of my slides. So.
Oh, no problem. Yeah, so we have a question, a point of clarification.
Yeah.
Where you said previously that your slide referenced Blacks not included as citizens. Does that mean enslaved Black people or all Black people?
Great. I'm so glad that was asked to be clarified, because I want to be clear. All Black people, and that's what was shocking. No one in 1857 thought of slaves as citizens, right? That the condition of slavery was just too anomalous to be, to conclude someone could be a citizen and a slave at the same time. Mm-hmm. 500,000 free Blacks, 4 million slaves, but 500,000 free Blacks. And they were given the right to vote and own property. Some owned slaves. I mean, they had a position of political recognition in many states. And yet Taney said, no, even free Blacks aren't citizens. And he had to reach that conclusion because the argument by Dred Scott was, I'm free and a citizen and can sue for my freedom. And Taney said, no, you're not even a citizen, whether you're free or not. And in fact, he should have ended the opinion there. For those readers here, you don't go on if you've decided your court lacks jurisdiction, but Taney went on. He wanted to address the slavery issue.
While folks are still considering then, yeah. Were there more explicitly stated citizenship rules in any of the state constitutions?
So that's a great question. And I don't know the answer in detail to that. I will say that at this time in history, in 1857, first of all, it was not clear what the status of citizenship was and who defined it. But there was a line of argument or belief that it was states that controlled access to citizenship, that citizenship was granted or withheld at the state level, not the federal level. And what Chief Justice Taney said is states should be free to give citizenship. They can do it, but they can't make anyone who's Black a citizen for the purpose of the federal law or the US Constitution. Okay. So they can't give that person the right to bring a case in federal court or get any other rights and privileges of national citizenship. And they can't make any other state acknowledge that citizenship, which was key.
That's really interesting. And so we have another point of clarification, which I'm glad that Eric has asked. So could you explain a little bit further about this concept of natural born citizen, particularly as it is in reference to Alexander Hamilton? Because I think a lot of people have heard, oh, Hamilton could have been president, but he wasn't a natural born citizen. So could you kind of explain that a little further for us?
Yeah, well, sure. The framers, and I wish I had a slide with this, but I don't know, I'll just paraphrase it. The framers were well aware of the possibility that some of them couldn't be president if they limited it to natural born citizens. So you could be president if you were a citizen at the time that, I can't remember now if it was 1776 or 1787, but you could be a citizen if you were there at the founding, even if you weren't born in the United States. So it was clearly not off limits for someone who wasn't born a US citizen. And of course, no one who could be president in 1787 was born a citizen. US citizenship has been dated as starting in 1776 with the Declaration of Independence. And of course, that's when the United States declared its independence, but Britain didn't recognize American citizens at that point. It was only after we won the war that the world recognized US citizenship, and it started in 1776. So you could be born a natural born citizen, or if you were a citizen at the time, as I said, I'm not sure if it's the Declaration or the Constitution, you could be president. So anyone who was a US citizen by then was eligible for the presidency. And then I see in the Q&A a question about outlining the case law rationale for the majority opinion. So the majority opinion goes beyond the citizenship point I've made. The rationale for the citizenship point was the ones I've just listed that Taney explained. He said, first of all, he couldn't reconcile a nation that allowed for racialized slavery, that in fact incorporated it into the Constitution as it did. He couldn't reconcile that idea with citizenship for Black people. And I think it's because to recognize Black people's citizenship, free Black citizenship, was to recognize their humanity. And that jeopardized the entire idea of racialized slavery. So as I said, Taney seemed to recognize the tension of hypocrisy. He just resolved them in the most odious of ways. Mm-hmm. He went on, of course, and the part of the opinion I'm guessing people are familiar with who are listening here is to say that it wasn't true that if you were a slave and taken into free territory that you became free. And in fact, in ruling that way, he really put at risk the very idea that had kept our nation from going to war, which was that there could be half free, slave, half free. Because if you could bring your slave into free territory and they remained slaves, then there was nothing to stop slavery from spreading across the United States. So his opinion was really radical because it upended this very delicate compromise that, of course, was going to have to end eventually. And the nation couldn't remain divided in this way, and they had to go to war over this. So in a way, his opinion, not his opinion alone, but it pushed the nation into war. It was one of the factors. And President Lincoln said so much in his House Divided speech. He cited this decision as one of the reasons the nation went to war. Okay, so I think if that's all the questions for now, I think I haven't missed any. I'm going to go on. But thank you for those. Those were great. And as I said, I love being interactive here. All right, so that takes me to the post-Civil War era, which I think the Reconstruction era is the most important moment for me in US history. And I think we're really beginning as a nation to realize that perhaps it was a really important moment that we haven't fully grappled with both its successes and its failures. So I think the citizenship battles that occurred in the wake of the Civil War say so much about us as a nation. And in this part of the book, I profile 3 different men. We have in the top left corner of the screen, Robert E. Lee, of course, the famous, and many of you are from Virginia, I don't need to tell you who he is, but the famous general who was a military leader of the Confederacy. Then we have Jefferson Davis there in the middle, the president of the Confederacy. And then on the right, we have a name that should be a household name, like I think Jefferson Davis and Robert E. Lee are, but it's not. I think hardly anyone knows his name. I did not know his name until quite recently. It's Hiram Rhodes Revels, who was the first African-American to serve in Congress. And in 1865, not one of these men was a citizen of the United States. And Robert E. Lee and Jefferson Davis had lost their citizenship by expatriating themselves. After all, they wanted to secede from the United States. They created a new nation called the Confederate States of America. They added their own flag, as we all well know. They had their own stamps, their own currency, their own government, their own army. They declared themselves to be a new nation. And in fact, the radical Republican Senator Charles Sumner described them as enemy aliens. And there's some Supreme Court precedent saying that they don't have the rights of citizenship. And at the end of the Civil War, these 2 men, Lee and Jefferson Davis, as well as all of the members of the Confederacy, certainly the leaders, but really everyone in those states, had lost the right to vote or to be represented in Congress or to have any political or civil rights altogether. So that was the situation in 1865. And of course, for Blacks, Hiram Rhodes Revels had never been a slave, but free Black or slave or emancipated slave, because by the end of the war, the 13th Amendment had been ratified, ending slavery, but it didn't grant Black citizenship. And Dred Scott said, no Black person, free or slave, could be a citizen. So Blacks also had no right to vote, no right to hold office, no right to exercise political power in this fractured and slowly reuniting nation. So that left a question of what's going to happen to these people. What's going to happen to the leaders of the Confederacy who had lost their citizenship by fighting to form their own country, and to the newly emancipated slaves and the free Blacks in the United States? What would happen next? Well, a reminder about the status of people like Jefferson Davis and Robert E. Lee. They were vilified, not of course by everybody, but by many people at the end of the Civil War. They'd been the cause of a bloody Civil War. So Jefferson Davis was arrested and buried alive, as the New York Times put it, in a cell in Fort Monroe. He was indicted for treason. Robert E. Lee was a prisoner on parole, so he went back to Richmond, Virginia, and then Lexington, Virginia, where he led Washington and Lee. But he was also indicted for treason. Treason carried the death penalty. And indeed, men like these leaders were executed. This is the scaffolding upon which Henry Wirz, the commandant of Andersonville Prison, the infamous prison where Union soldiers were starved and abused, he was hung on this scaffolding. You can see the Capitol there in full view. And in fact, where this scaffolding was erected is today the US Supreme Court. So the site of the Supreme Court. for those who are familiar with Washington. And you can see what a spectacle this was. You can see the men sitting in the trees watching this. And there were many who called for the execution of Lee and Jefferson Davis. And there was some significant chance this would happen. And in fact, President Johnson said he thought they should be hung, and he certainly wasn't going to give them their citizenship rights back. So Johnson initially pardoned all of the folks who weren't the leaders of the Confederacy in a sweeping pardon, but he wasn't going to grant pardons to the leaders of the Confederacy at first. And so Lee and Davis remained non-citizens for the years following the Civil War. Lee couldn't vote, Davis couldn't vote, and they couldn't hold office. And then the next question was, well, what's going to happen next, both to the emancipated slaves and to these leaders of the Confederacy? And the radical Republicans in Congress realized they had to do something quickly. They had to be sure that the newly freed slaves got citizenship before the Confederate leaders got their citizenship back. And the reason for that was this provision in the Constitution, the 3/5 compromise. So under this provision, the seats in Congress are allocated by the number of whole persons in each state, but only 3/5 of enslaved persons could be counted. So that meant, depending on the year, there was between 18 and 30 what we call slave seats in Congress. Seats in Congress that were allocated to Southern states based on their slave population. And of course, slaves couldn't vote or couldn't be elected to office. So this was power given to the white slave owners on the basis of counting their slaves. So ironically, after the Civil War ended, if the Southern states rejoined the Union, as everyone wanted them to do, the former slaves would count as one whole person, giving the South even more political power in Congress. And if the leaders of the South had their way, none of these people could vote. So the Southern white former slave owners, former leaders of the Confederacy would have even more political power than they'd had before the Civil War. And they already had outsized political power by using their slaves to add to their representation in Congress. So this was a great concern to the radical Republicans in Congress, who of course had opposed slavery, supported Lincoln, supported abolishing slavery, and supported fighting the Civil War. So the solution they came up with was the 14th Amendment. So the 14th Amendment, which Eric Foner, the great historian, refers to as the second founding of our nation, that first sentence says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. So this makes it clear, birthright citizenship for all. But that's not all the 14th Amendment did. And that's of course important because it said all the former slaves are citizens of the United States. And of course, today it goes beyond that, and we'll talk about the children of immigrants and the children of undocumented immigrants who are also automatically birthright citizens, although there remains some controversy about that. I don't think there should, but there remains, as we've seen from our previous presidents, some debate about that. But what I find really interesting is Section 3 of the 14th Amendment, which we rarely talk about. This was the section that said to people like Lee and Jefferson Davis, you are not full citizens, and we are not giving you back citizenship rights. In fact, we are barring you from holding elected office in the federal or state government if you took part in the previous insurrection or rebellion against the United States, unless that disability is removed by Congress in a 2/3 vote by each house. So the same amendment that made Black citizens made these former leaders of the Confederacy permanent less than citizens. I won't quite call them non-citizens, but they lacked all the rights of citizenship. And in fact, that takes us to Hiram Rhodes Revels, who in 1870 was elected to be the senator of Mississippi, the first African-American to serve in Congress. And what was, everyone recognized, a great symbolic moment. Revels was taking over the seat that had formerly been occupied by Jefferson Davis. And this is a political cartoon by Thomas Nast showing a bitter, angry Jefferson Davis slinking away, barred by the 14th Amendment from ever serving in Congress again, watching as Hiram Rhodes Revels takes his seat. So this was an important symbolic moment, but it wasn't going to be an easy one. No one was going to make it easy for Senator Revels. And in fact, when he tried to take his seat in Congress, those senators who opposed the idea of a Black man serving among them said he is not eligible. And the reason they said he wasn't eligible is he hadn't been 9 years a citizen of the United States, which is required in the Constitution to be in the Senate. And they had two arguments. One, they said, well, even if the 14th Amendment made him a citizen, it's only 2 years old, so he hasn't been a 9-year citizen, he's only been a 2-year citizen, meaning no Black person could be a senator or a representative for the next 7 years at least. And then a large number also said the 14th Amendment was invalid. So I have a quote here from Garrett Davis of Kentucky, who said the 14th Amendment is no more a part of the Constitution than anything which you might write upon a piece of paper and fling upon the floor. And he said that on the floor of the Senate. And this was the view of these either former border states or slave state members of Congress. The 14th Amendment wasn't really part of the Constitution. It wasn't real, it wasn't authentic, it wasn't valid, it wasn't legitimate. They refused to recognize that a Black person could be a citizen and that Dred Scott had been overruled. So they lost this battle with Hiram Rhodes rebels. He was seated 3 days later, it took 3 days, and he wasn't alone. He was joined by a group of other Black men who joined him in Congress, as in the House of Representatives or in the Senate. And in fact, Blacks obtained office throughout the South. This chart shows you, or graph shows you, that the red line is the number of African-American Southern legislators serving in office from 1868 to 1900. As you can see, that number went way up and then fell way down as the country abandoned Reconstruction and stopped fighting to protect the rights and citizenship rights of African Americans. And eventually African Americans who registered in large numbers and who voted in large numbers, and they were the majority in a number of Southern states, including Mississippi, Blacks stopped being able to vote. They were threatened through violence, through things like the poll tax, the grandfather clause, the literacy test. They were barred from voting and eventually stopped serving in office, stopped being elected. But they were very successful in this Reconstruction era in obtaining office. And by the way, the blue line, which is not directly relevant to my book, but nonetheless interesting, shows the effect of the Voting Rights Act, which after it was put into effect, enabled Blacks to be elected again to office from the Southern states, which they had not been able to do until that law came into effect. So just a couple more points to make, and more along those cultural lines of who gets to be a citizen and who's not. So the 14th Amendment clearly made all African-American citizens of the United States, and it barred Confederate leaders from serving in office or having all those citizenship rights. But in the years following, after the abandonment of Reconstruction, we see this cult of the Confederacy forming. We see all of these Confederate symbols and monuments being erected in the United States, and that's a map showing the situation in 2017. This is the statue of Robert E. Lee in Charlottesville, Virginia, which of course led to its efforts to take it down, led to the fatal protest / riots of a few years ago in Charlottesville. This adulation that these Southern leaders received reached its peak in as late as 1975. And here I'm showing you a picture of Gerald Ford signing a joint resolution by Congress sent to him in 1975. And the resolution, purely symbolic, but importantly symbolic, was to give Robert E. Lee his citizenship rights back. And as you see from the quote here, Ford said as he signed it, and this is on the steps of the Lee family home in Arlington Cemetery, on the grounds of Arlington Cemetery, General Lee's character has been an example to succeeding generations, making the restoration of his citizenship an event in which every American can take pride. And in 1978, Carter signed a very similar piece of legislation giving Jefferson Davis his citizenship back. So that really exemplifies how this citizenship battle played out, not just in terms of the legal rights and privileges of citizenship, but in terms of the sense of who belongs and who's an American. And I'm actually happy to take questions, if you have them later, about, do I think Lee and Jefferson Davis should be acknowledged as US citizens? Because my answer might surprise you in light of the way I've been speaking, but I think it's a very interesting question and one that I'd be very happy to take in the Q&A as I move on from this subject. The last slide I want to show you here, though, is there's very few monuments for Hiram Ramos, and this is the two I could find. That's his very modest gravestone, and that's a plaque on a highway. So he doesn't get all the recognition that these Confederate leaders have gotten, which of course is why he is not a household name. All right, so I'm going to move on now and talk about the next chapter in these citizenship battles, and a very important one. Moving forward in time to the 1870s, we have here a picture, a drawing of this pogrom, I don't think there's another word for it, in Chinatown in Los Angeles in 1871. And Los Angeles in 1871 was a backwater. It was Chinatown was one alley, a muddy alley with 200 people in it. But more than a dozen Chinese and Chinese American men were hung, were lynched. Many were had all their goods stolen or their homes burned. One man, his finger was cut off to get at his ring. I mean, it was horrific. And it was in the front page of all the newspapers in the nation when this happened. And this was in part due to this extraordinary anti-Chinese animus that started on the West Coast, but eventually convinced Congress to pass the Chinese Exclusion Act of 1882. And before the Chinese Exclusion Act, there really was no such thing as an undocumented immigrant or illegal alien, as people also refer to them, because there wasn't such a thing as someone who wasn't permitted to come to the United States. There was very few restrictions on immigration. So the Chinese Exclusion Act was the first such law, and it was the first, of course, to target a group based on its race. So Chinese had been permitted to come before that, Chinese immigrants, and a few were permitted after if they were of the merchant class, but it restricted Chinese immigration very significantly. And that led to problems for this man, Wong Kim Ark. He should also be a household name, in my opinion. He was born in San Francisco to two immigrant parents, Chinese immigrant parents, both legal immigrants. There wasn't illegal immigrants back then, and they'd come to the US to work. And he was born in Chinatown. He was one of only about 500 children of Chinese immigrants born in the United States at that time. He lived in the United States for most of his life, but anti-miscegenation laws made it illegal for him to marry a white woman, which may be part of the reason he traveled back to China, both to meet relatives and also to get married. And then he came back into the United States in 1895 on a steamship. And when he tried to enter the country, the US government, who'd been looking for a case to challenge birthright citizenship for the children of Chinese immigrants, they chose him. And they said, you're not allowed to disembark. In fact, he had to remain on that steamship for months because we acknowledge you were born in the United States, but we don't think you're a US citizen, despite the language of the 14th Amendment that said all born in the United States are citizens. The government said, nope, not for the children of Chinese immigrants. So Wong Kim Ark got a lawyer. In fact, Chinese immigrants and Chinese Americans were incredibly litigious and very successful. And I think the NAACP gets a lot of credit for this. I think the societies of supporting the Chinese should get credit too. They hired establishment lawyers to argue cases on their behalf. And these lawyers took on Wong Kim Ark's case. And they said, of course, he's a citizen. The 14th Amendment makes him one, the very clear language, intending to get rid of, in the words of Charles Sumner, oligarchy of skin and caste in the United States. That's the purpose of birthright citizenship. We're all born equal. Doesn't matter who our parents are, whether they're immigrants or we're slaves or whatever their status or race or religion or creed, we are all American at birth. And that was the great principle of the 14th Amendment's birthright citizenship clause. But Wong Kim Ark's lawyer he was smart enough to know this might not always fly with the Supreme Court, which had quite a bit of anti-Chinese animus as well. They're products of their time, as is always true of the court. So he very wisely didn't make this case about the children of Chinese immigrants. What he said to this US Supreme Court in his oral argument is, if you say that a child of immigrants is not a US citizen, you're not limiting that to the Chinese. You are also going to take away the citizenship from the millions of children born to Scottish immigrants and English immigrants and Irish immigrants and French immigrants who also live in the United States. And so if you do this, and this case was argued in 1897, and immigration was high, and there were many children in that status, you are going to strip citizenship from and disenfranchise hundreds of thousands, if not millions, of people who think they're American. And in fact, the oral argument in this case was postponed until after the presidential election. And in part, that was because everyone recognized this question was about who could vote, right? Not just who was a citizen. So moving on, this is the picture of the Supreme Court at the time. Melvin Fuller there in the middle, who was very short, about 5'3", so I always had a little footstool. And no one knew how this court would decide this case. It was a close question. But they voted 7-2 in favor of Wong Kim Ark. They declared him to be a US citizen. And they said everyone born in the United States, regardless of the status of their parents, are citizens. So they supported that principle, and they put an end to those arguments made by the government, one thought, at least for that time. So let me see, I think I can't see there's a question in the chat, but
There is, yes.
Yeah.
So
I'm not looking into it. Yeah.
the question is, has
Yeah.
Section 3 of the 14th Amendment ever been used against public officials following the Civil War or
So
since that era?
no, but what's fascinating is there was an op-ed in the New York Times by a couple of lawyers I know arguing that Section 3 should be used to bar Donald Trump from ever holding elected office again, because the argument was he supported an insurrection and it could be used to bar him from holding office. And it would take a 2/3 vote of Congress to remove the disability. So it was a very interesting argument. It hasn't been picked up on, and no, that section is not, as far as I know, I haven't, I don't want to say that there's never been a moment, but I was very interested to see the argument in the New York Times just, shortly after that January 6th invasion of the Capitol. But it wasn't picked up on by politicians. So that's the one time I've seen it been used more recently. But it did serve to disable and prevent the former leaders of the Confederacy from holding elected office for a period of time. All right, so moving on, I want to now talk about the situation of women and the citizenship of women. And this story is particularly uplifting, at least for me. And I really enjoyed researching and writing these chapters and looking into the situation of women. So, we just celebrated the centennial of women's right to vote, where the 19th Amendment added to the Constitution in 1920 guaranteed women in the United States the right to vote. But it was a long and hard-fought battle that began long before 1920. And in fact, California was the real linchpin to the women's right to vote, because California voted on that question in 1911. Oops, let's see, I think this slide there. It has a statewide vote on whether women could vote in California in 1911. And the women of California who were in favor of this fought long and hard for this. And they mobilized in every way you could mobilize. I love the sign, give your girl an equal chance with your boy. They were appealing to the parents' sense of wanting the best for their daughters, because of course they had to convince men to vote to give women of the state the right to vote. And it was a close question. Let's see, I think it was a close question. And sorry, I won't flip ahead yet. And one woman who was instrumental in the fight for women's right to vote in California was a woman named Ethel McKenzie. And Ethel McKenzie was a fascinating figure. She was a socialite. She was the daughter of a wealthy vineyard owner. And she was well known, covered in the San Francisco papers. Her wedding was described in detail. And she married this handsome, famous singer who was well known as well. And they were just this glamour couple. But he was Scottish. He had never naturalized. He was not a US citizen. So Ethel McKenzie is busy fighting for California women's right to vote. And she wins. She and her sisters in this battle won the right to vote for women by razor thin margins. And then she goes to vote. And she's trying to cast her first vote that she fought for. And the registrar says you can't vote because under a 1907 federal statute, women who marry non-citizens automatically lose their citizenship. Whether they're naturalized or native born, doesn't matter. By marrying a non-citizen, you have lost your citizenship. So she was not the kind of woman to just accept that. And she was absolutely outraged. And she brought a case to the US Supreme Court, where she said the 14th Amendment says I'm a citizen. Congress has no right or power to take that away from me under the Constitution. And so I both should remain a citizen and remain able to vote despite having married a non-citizen. So you see there's some newspaper coverage of this, wife of foreigner not allowed to vote. Mackenzie Gordon worked hard for a right she cannot exercise and it came as a shock, etc. She got a lot of sympathetic press coverage, but the Supreme Court had none of it. In 1915, they issued a unanimous decision against her. And they said she chose to marry a non-citizen, so she lost her citizenship. End of the story. She can't vote. The marriage of an American woman with a foreigner has consequences. They're sort of scolding her here. Therefore, as long as the relation lasts, it is made tantamount to expatriation. So she lost her citizenship and couldn't regain it. Eventually, her husband naturalized, and she became a citizen that way. But that's not the end of the story. What I love about the story is first women fought to get their citizenship back from Congress, which of course had taken it away. And Congress held hearings on this issue in 1917, 18, and you read these transcripts and they're basically laughing. They think it's a silly issue. They think women, they say, you should just marry good old American boys, is what they tell these women. Well, then women get the right to vote in 1920. And very shortly thereafter, Congress says, this is really a problem that women lose their citizenship, and we need to give it back to them. And the reason is they were worried all the women who remain citizens would punish them at the polls. It's interesting to see how political power changes the conversation very quickly. So some aspects of the law were repealed, and I won't get too technical here unless you want to ask me questions about it later. Some parts of the law were repealed, but not entirely, not completely. So enter the next person, the next hero of my story, Ruth Bryan Owen. She was the daughter of William Jennings Bryan, who had run for president multiple times, never won, but had been quite influential in the Democratic Party. And she was just an amazing human being, an incredible public speaker, incredibly dynamic woman. She had 5 children. She ran a household. She earned the sole living for her household because her husband, a British officer, had been wounded in World War I and couldn't work. So she was as modern as they come. She was a fascinating person. And she ran for Congress. I think politics was in her blood because of her father. And she won elected office in 1928, the first woman from the South to win office. And she won by a landslide. She was amazing. Her challenger, though, the man who lost, said, well, she's not a citizen because she married this non-citizen and lost her citizenship. And while she gained it back, she hadn't had it for long enough before the election to qualify as a citizen eligible to hold office. So this should remind you of Hiram Rhodes Revels, right, who had the same citizenship battle to fight. And she actually had to defend her citizenship and eligibility in front of her male colleagues in the House of Representatives. And they voted to seat her. They had none of it. I think they recognized it would be very unpopular to say the woman who won by a landslide wasn't really a citizen who could serve. So she was elected to Congress along with a handful of other women. This is a picture of the women elected to Congress that year. And then what did she do with her political power? Well, among other things, she helped dismantle the last vestiges of the law that took away women's citizenship for marrying non-citizens. So she helped repeal the law that had almost barred her from holding office, that barred Ethel Mackenzie from voting. She used that political power to put an end to this law. So I just love the end of the story and the fight that, even though at that point it didn't affect her, she said, I'm going to end this for these women who've lost their citizenship. So moving on now to the post-World War II era, which is another really interesting and important moment in citizenship in the United States. Here's a picture of a man, again, I'd never heard of, but a fascinating figure, thankfully not too influential in the United States, although he could have been. Fritz Julius Kuhn. He was born in Germany, claims to have been part of Hitler's attempt, putsch in 1923, to attempt to take over the government, fought in World War I, then emigrated to the United States, became a naturalized citizen, and then became leader of the German American Bund, which is a group of German American society that at different points in its history was very pro-Nazi, very pro-Germany. And he openly declared he wanted to be the American Hitler. That was his goal. And he also believed in citizenship by blood. He believed that you couldn't be born a citizen just by being born on the soil of a country, that citizenship was all about blood and race. And he said, we are all of us Germans in America. He didn't call himself a German American. He was a German in America, as were, he said, everyone else who had German ancestry. We are all German, and we're German by blood. And of course, the society was overtly anti-Semitic. And he was at times influential and successful enough, enough to be somewhat scary. This is a picture of Madison Square Garden, a rally in February 1939 with people raising their arms in the Sieg Heil salute, and the swastika prominently displayed. 20,000 people showed up. He had some influence and some power by those who supported Nazi Germany. And of course, this was before the US went to war. So Kuhn was one example of an individual who both believed that citizenship was by blood and by race, not by birth on US soil or by affiliation, naturalization in the United States. And he fought for those principles. So the vast majority of German Americans did not support him, and the vast majority were completely loyal to the United States. And I don't want to suggest otherwise, but he is an interesting example of a small group who were not. At the same time, we had a very small number of individuals, Japanese immigrants and Americans of Japanese descent. So the children of Japanese immigrants born in the United States, living mostly on the West Coast. And there was concern about their loyalty, but there was lots of studies into it, including an FBI investigation before the war there was no evidence of any disloyalty among the Japanese and Japanese American population. Nonetheless, as I'm guessing the audience is familiar with, the United States decided to imprison the Japanese American population and the Japanese population of immigrants living on the West Coast. And you see this was favored by the great majority of Americans who were terribly afraid after Pearl Harbor and after a string of losses in the Pacific, and they reacted by this racist view that the Japanese were not going to be loyal, whether citizen or not. Here's a picture of all persons of Japanese ancestry being instructed to go to holding centers where then they were taken to the, what they were actually at the time called concentration camps. I think prison camp might be a better term, just the concentration camp term is really now indelibly associated with the death camps in Europe during that time. But these were prison camps, and we should never forget it. I mean, we can see these pictures of these desolate camps with barbed wire, and there were towers with men with guns keeping these people inside. And I had known all of this, of course, but what I hadn't realized when I started this book was that in addition to imprisoning Japanese Americans, the United States decided, let me see, go back a second. The United States decided that it was wanted to encourage Japanese Americans to renounce their US citizenship. And the goal was to deport them from the United States and even to trade them for US citizens held hostage in Japan or held in Japan. And this was unprecedented. No one had done this before, but Congress passed a law making it possible to renounce citizenship. And let's see, let's go to the statistics slide and then I'll go back. In fact, 5,589 Japanese Americans did renounce their citizenship. So 1 out of every 14 Japanese Americans did. All of them imprisoned and coerced into giving up their citizenship. What's interesting is, in the years that followed, almost all of them asked to have their citizenship back. And by the end of a long fight, they were almost all granted their citizenship back. So this was one of the grave mistakes the US made in this period of time in its treatment of its US citizens of Japanese ancestry. In this chapter, I profile this man, Joseph Kurihara, who was imprisoned in Camp Manzanar. He was born in 1895 in Hawaii. He was born a US citizen. He fought in World War I. And he renounced his citizenship because he was so incredibly angry at the way the United States had treated him. And he moved to Japan. And he never chose to take his citizenship back. But he did learn from a sibling that the United States had apologized to the Japanese Americans who'd been imprisoned and apologized for coercing them into renouncing his citizenship. And that was enormously important to him, and he wrote about it. And so it's a happy end to what is otherwise a very sad story, that this man who was a very loyal US citizen fought in World War I and felt very poorly treated by his government, but in the end recognized the US had apologized, and he said, "I forgive my nation," because the US government asked for the forgiveness of those it had taken the citizenship from, which is, I think, a nice postscript to the story. Another interesting postscript is that Fritz Julius Kuhn, the leader of the German-American Bund, who claimed that citizenship was based solely on race and that he was German, he was denaturalized and he was sent back to Germany. And in the end, he tried to petition to get his US citizenship back. He felt it was more American than he claimed to be at the time, that he was claiming to support Nazism and believed that citizenship was all about race. The US government did not give him his citizenship back. So as I mentioned, this very significant renunciation of citizenship was followed by the decision to give it back. So as I said, that's a happier postscript. I want to move on now to talk about citizenship stripping based on ideological viewpoint, based on beliefs. And Emma Goldman, who many of you may know her name, she was an anarchist who, in addition to supporting anarchism, the idea that man should rule himself and an anti-government view, she also was a fighter, supporter of labor rights for the lower classes. She herself had worked in a factory and then been a midwife on the Lower East Side of New York. And she was very clearly targeted by the government, who decided they wanted to take away her citizenship. She was a naturalized citizen. They wanted to take away her citizenship so that they could deport her. And indeed, the government succeeded. So she, along with 249 others, was put on this boat, marched onto this boat, and she was deported away from her country. She later wrote a very moving essay about, she said, I'm a woman without a country, and she'd lost her home. And she never came back to live, although she did come back occasionally to give tours and lectures. She remained an influential speaker. But she lost her citizenship and her country as a result of her political opinion, as did this man, Harry Bridges, who was another remarkable figure. He was born in Australia, came to the US, naturalized, became the leader of the longshoremen and harbor worker. He himself was a harbor worker. And the conditions were very unsafe, the hours long, the pay low, and he fought for their rights. He led a general strike in San Francisco in the 1930s. That was the first successful general strike of its kind, and the government went after him. The government said, let's get rid of this guy, as it did to others during the Red Scare era of the 30s and then again in the 50s. And it tried in 4 separate trials to deport Harry Bridges. His case went to the Supreme Court not once, but twice. And every time he won and managed to retain his citizenship and managed to remain in the United States. And then at his retirement, he was praised by the leaders of San Francisco, by the Secretary of Labor, came to a special ceremony for him, and he joked about it, said, no one, no man gets such respect as when he's retiring. That's when we all started to decide we respect him. But he was very clearly targeted for his political activity, as were many, many others during this era. So he and Emma Goldman are examples of ideological or political-based denaturalization. And then moving on to even more recent times, this is a picture of a woman who's still living, Amelia Castaneda. She was born, I can't remember now, I think it's the late 1920s, maybe early 1930s. And she and her brother and father were among, there's debates about the numbers, somewhere between 300,000 and 1 million families of Mexican and Mexican Americans living in the United States who were coerced or forced to leave the United States during the Great Depression. And the goal was to get rid of these families and not to let them back in. And in fact, Amelia Castaneda made it back into the United States, but only because she had someone help her find her birth certificate and prove to immigration officials that she was a citizen of the United States, because of course she'd been born in the United States. So I tell her story, which was part of this mass repatriation in the 1930s. And here, this is another picture showing all of these people waving goodbye to family members who have been put on trains and forced to leave the United States in the 1930s. And then in the 1950s, it happened again. And under the Eisenhower administration, it was called Operation Wetback, and offensive name, of course. And it was used to round up Mexican and Mexican Americans, very little attempt to differentiate between the two. And of course, many families were in mixed statuses with US citizen children and non-citizen parents, and forced them to leave the United States. And some of that group made it back and many did not. And there's some very powerful documentaries. All right, so that takes me to the end of the historical era. I still want to talk about some of the events today, but why don't I see if there's any questions or comments so far?
Yes. So we have a question in the Q&A from Gail. Yeah. On what basis did the Supreme Court decide Bridges' citizenship could not be rescinded? Have they ever tried to rescind citizenship of a native-born citizen?
Yeah, so the Bridges case is fascinating. So the first thing they said was, there were several cases and a whole lot of different legal arguments. So one legal argument, the Supreme Court, the first Supreme Court case, they said, the government, Bridges was very open that he supported various communist viewpoints, but he said he was not a member of the Communist Party and the government couldn't prove it. And under the law, that's what they had to prove. Not just that he was a member of the Communist Party, but also the Communist Party wanted to violently overthrow the US government. And the Supreme Court said in very strong language, having a set of beliefs is not the same as that are in line with the Communist Party doesn't make him someone who wants to overthrow the US government. The US government has not proven that, and therefore we can't deport him for his speech. And it was the beginning of the protection of the First Amendment rights that I think are now more strongly protected today than they were then. And in the second case, it was actually on a technicality. The Supreme Court said, we're not going to reach the merits. We decided the government has brought its case too late. They missed the statute of limitations. They should have moved faster to remove him. And that may have been the Supreme Court's way of dodging the issue a little bit, but they didn't address the merits about whether or not he was a member of the Communist Party or had engaged in any of this activity the government said was the basis for deporting him. They just said, you brought your case too late. But the government tried 4 separate times to deport him, which is just remarkable. And to go to the Supreme Court twice, again, it's remarkable. And the FBI used to tail him, used to put tails on him, follow him around, and he knew this, Bridges did. He would try to mislead them. At one point, he called up a friend and he said, "I'm going to meet Mr. Big." Started pretending to use a code name. He knew his phone was tapped. And then he just traveled around San Francisco, stopping at one shop or the other. And the FBI guys are like running around behind him. And he's just having a good time. And the New Yorker even did a little piece on it, saying, Harry Bridges has fun with the FBI. Kind of made the guys look foolish. In the end, he came very close to being deported, and he had a wife and children. So I think he was a little casual about this, but he won the day in the end. And then did native-born Americans lose their citizenship? Well, they couldn't be. I'm going to talk about denaturalization today, and I'll get a little detail with that. The folks I've talked about here were denaturalized, or that was the attempt. Mm-hmm. But native-born folks could lose their citizenship, as I've explained, with, for example, women who married non-citizens, as an example of that.
And James asks, and I know that the answer to this is yes, but do you address Native Americans in your book?
Yes, but yes and no. And James, I'll tell you why. So I do, but not in detail. And that's because, first of all, Native American citizenship needs its own book. Because Native American citizenship, so for every other person I profile, and in almost every other situation, to take away citizenship or to deny citizenship is an act of denial of civil and political rights. And it's clearly an attempt to disempower the person or the group. For Native Americans, though, it was different. And that's why Native Americans are actually not included in the 14th Amendment's birthright citizenship clause. Mm-hmm. The reason being, it was viewed by the Reconstruction Congress as undermining the sovereignty of Native American tribes to do that. Now, today, by statute, a statute enacted in 1924, Native Americans are also citizens at birth. So they are born U.S. citizens like everybody else. But the view was to give them automatic U.S. citizenship was not an empowering act as it was for the newly freed slaves. It would undermine their status as a separate sovereignty, belonging to a separate sovereign, members in a separate sovereign. So in that way, it's much more complicated and interesting. And I think, as I said, it really deserves its own book. And I can recommend articles or books to you. Bethany Berger, a law professor at Connecticut, has written a great article on some of the case law and some of the issues with Native American citizenship, among others, who's written on that topic. All right. So if that's it for the questions right now, I think it is, right, Emily? Yeah. Yes. So I am going to move on and talk about citizenship stripping today, because as I said, my book is not only history. And particularly during the Trump administration, my last chapter is citizenship stripping today, and it kept getting longer and longer as I wrote it over the last 2 or 3 years. So I'm not going to talk about all of these issues in detail right now, but I'll flag a few of them, and I'm happy to answer questions about others. There's a number of ways in which people today can lose their citizenship. It is not over. Now, it's a little different than in the past. Often, citizenship stripping takes the form of proof of citizenship. How do you prove you're a US citizen, particularly if you're born in the United States? So no longer does the government say, well, we're just going to assume that, or say, without any basis, that if you're of Chinese ethnicity, you're not a citizen, right? That's what they said to Wong Kim-ark. They don't do that today. But the government does say you need to prove you're a citizen. And it turns out to be a lot harder to do that if you are of Mexican heritage and live near the southern border, for example. So, for example, the government takes the position that if you are born near the southern border and you are born outside of an institutional setting, so not in a hospital, that you're presumptively not a citizen, even if your birth certificate says you're born in the United States. Now, first I should note, it's quite normal to be born outside of a hospital near the southern border. Hospitals are few and far between. Using midwives is quite common. And there also has been some fraud involving midwives willing to sign birth certificates of children born in Mexico. So there's some examples of fraud. But that doesn't mean that every child who claims to be born in the United States is an example of that fraud. And for those who are in this position, how do you prove you're a citizen if your birth certificate is not evidence of that, right? Obviously, for those born anywhere, we can't prove it, right? We weren't cognizant of where we're born. The government has on its websites things like, well, show a family Bible that says where you're born, or show a certificate from your primary school or your vaccination record. If you have those records, great. But often having those records is a sign of being, I think, upper middle class or wealthy. Most people don't keep those records. I don't easily have proof of my citizenship beyond my birth certificate, right? And now my passport. So when I think about this, I think, this is an example of citizenship stripping, not overt, but it's the same thing for those who are denied passports. And some of those who had passports, but were later questioned, were barred from entry in the United States, or were detained and are at risk of deportation. So this is very serious consequences for that group. Also, I'll talk in a minute about the denaturalization campaign under President Trump. Proof of citizenship needed to vote, which is something that Chris Kobach tried to do in Kansas. And it disenfranchised tens of thousands of Kansans who were citizens but couldn't prove it in time to vote and register to vote. There's also mistaken arrests and detentions of US citizens that happen with disturbing frequency. And President Trump threatened to end birthright citizenship for the children of undocumented immigrants. He didn't follow through, but he threatened it many times, which in itself is destabilizing, I think, for that group. So I'm going to first talk about denaturalization as I think a topic of interest and also probably the most serious threat to citizenship during the last 4 years. So first, you should know the background here is this case Afrayim versus Rusk from 1967. I already told you about Goldman and Bridges and this example of ideological citizenship stripping. And you could lose your citizenship for things like voting in a foreign election, serving in a foreign army. There was lots of grounds. And finally, in 1967, the Supreme Court said enough. We think citizenship, whether naturalized or born a US citizen, is protected by the 14th Amendment. And the government is not allowed to denaturalize its citizens for all these extraneous reasons. The only reason it can do so is for fraud. And in fact, they cited this provision in the Constitution I've already talked to you about that says very clearly, all born or naturalized are citizens. The Supreme Court had recognized that naturalized citizens are equal to native-born citizens. There's no difference. They're treated the same. Which is one of the reasons it wanted to protect them from the potential of losing citizenship. Because of course, if you make it easy for a naturalized citizen to lose citizenship, you've created an unequal status. But Afrayim versus Rusk had this footnote. Naturalization unlawfully procured can be set aside. And by the way, I think that's correct. I think it's correct that if you have some serious problem with your naturalization, for example, maybe as in the past has happened, a Nazi prison camp guard, some other perpetrator of crimes against humanity, lies about his identity, comes to the United States and gets citizenship, and this is discovered shortly thereafter, I agree that person should have their citizenship revoked. So I don't particularly disagree with this exception in Afrayim versus Rusk for some sort of fraud. And I also think it was handled pretty well in the years following Afrayim versus Rusk. Under both Democratic and Republican administrations, very few people were denaturalized. And the people targeted for denaturalization were the sort of war criminals who'd lied about their pasts and their identities. So an average of 11 people were denaturalized a year during this period of time, right up into the Trump administration. Denaturalization was extremely rare, right? So cut to Donald Trump taking office. Denaturalization was very openly and overtly described as an immigration control measure and as something the administration wanted to very actively engage in under what they called Operation Janus, which is Janus is the god facing both directions. And this idea, I think it's a perfect name because the idea was if you're a naturalized citizen, you're never safe because we can always look back at your past and see if there's some grounds to denaturalize you. And you might say, well, okay, that's not so bad as long as those grounds are serious fraud or lying in a serious way in your naturalization application. But let's go back here and look at the law for a minute. Under the federal law governing denaturalization, the government can denaturalize a citizen for two reasons. The first is because of concealment of a material fact or willful misrepresentation. So that's lying in some significant way. Or, and that's a very important or, because a denaturalization was illegally procured. That's been interpreted to mean any error at all in the application for citizenship or the green card application that came before that, or the initial entry documents in the United States. All of those could be grounds for denaturalization, even 30, 40 years after someone becomes a citizen. And an example of this, it came up in a Supreme Court case. A question on the naturalization application is, have you ever committed a crime or offense for which you were not arrested? Now, first of all, every single one of us needs to raise our hand and say yes to that question. I mean, I've jaywalked. I've occasionally driven a few miles over the speed limit. You might think, well, the government would never apply the law that strictly if a naturalized citizen said no, and it turns out they'd driven over the speed limit but not been caught. That wouldn't be grounds for denaturalization. That's what a reasonable person would think. Before the US Supreme Court in 2017, the Assistant Solicitor General of the United States was asked this question by Chief Justice Roberts. He said, would you think you had the right to denaturalize someone who had driven over the speed limit, not been caught, and answered no to this question because it's an incorrect answer? And the government said, yes, we could denaturalize someone for that reason. So this shows you they take this very seriously, and the ability to be naturalized for even denaturalized, even for minor errors on naturalization applications is, is a real risk for naturalized citizens. Again, it wasn't something the government was doing a lot of until Trump. But under President Trump, denaturalization became a focal point of its Department of Justice. It expanded its investigation into naturalized citizens to see if they'd committed some sort of error in their applications, admitting to investigating 700,000 naturalized citizens. There's 20 million total in the US. No one knows who they are. If you're a naturalized citizen listening, it might have been you because we don't know who they were investigating. They opened an office in Los Angeles, hiring dozens of attorneys to investigate at a cost of $207.6 million. And they announced they'd be referring 1,600 cases to the Department of Justice for denaturalization. They wanted to do that every year. They weren't nearly that successful, but they had that as their goal. So from 11 a year to 1,600 a year. So these were the first three targets, these three men. All of them had been naturalized citizens for over a decade. All were married to US citizens. A few of them had US citizen children. None of them had a criminal record, none of the three. I went to the trial of this man, Parvez Khan. He did in the end lose his citizenship. And the most striking moment for me was at the trial, his brother testified on his behalf. The brother was also a naturalized citizen. The brother was there to testify about his brother who was being targeted, this man, Parvez Khan. But the government starts asking the witness about his naturalization and suggesting it was fraudulent, which proves the point that when you start, if your view is you could denaturalize for even minor errors any naturalized citizen, then every naturalized citizen is at risk, and none of them can feel safe taking any position that brings them to the government's attention. Which is why I've included this quote by Masha Gessen, who's a New Yorker reporter, and also herself a naturalized citizen. And she says this denaturalization campaign has undone my citizenship, right? It's taken away my assumption of permanence. It doesn't matter if they actually go after me. The very fact that they can suggests I'm at risk and I will always be watching what I say and thinking about what I do. So I think I'll let her words speak for themselves, but that's a very powerful testimony to me about the effect of this on naturalized citizens. I've already mentioned the denial of passports to those born near the border. Talk for a minute more about the detention and deportation by mistake of US citizens. So there's a political scientist at Northwestern who studied this, and she says through her estimates of the population of mistaken detentions, that is American citizens who've been mistakenly detained, about 1%, so about 3,000 people a year. Some are deported, and there's been some really interesting reporting and documentation of that. This is an example of a man who'd been formerly in the military who was detained and held by the Immigration and Customs Enforcement for a month until he could prove his citizenship. So an example of this happening. And I'll conclude here by talking about President Trump, who in tweets and other comments wanted to end birthright citizenship for the children of undocumented immigrants. I'm happy to talk about that more, about the legal arguments that he claimed supported that, and why I disagree with them, why I think it harkens back to Wong Kim Ark. And also how just by saying that, I think he undermined the status of this group, that is the children of undocumented immigrants. Also, if he were to succeed in taking away their citizenship, he would massively expand the population of undocumented immigrants, and it would lead to tens of millions of people living permanently excluded from membership, in creating the very caste system that the framers of the 14th Amendment wanted to prevent. So the final point I'm going to end with, and then I hope there'll be a few more questions or comments, but I know it's getting late, is an NBC poll from July 2016. Because of course, a lot of this modern era started, you may remember, when not just President Trump, other elected officials even questioned, but then Donald Trump, now later to become president, rose to prominence by questioning the citizenship of Barack Obama. And here I see Hiram Rhodes Revels. I see, echoes of these questions about who could be a citizen in Dred Scott coming back here with Obama. And what shocks me about this poll, and I think it opened my eyes, I thought this was ridiculous at the time, this birtherism point. I would never have talked about it in class or at a presentation like this. I thought it was a joke. But when you look at this poll, taken in July 2016, Obama had been president for 8 years. You see, well, definitely we're divided by our Republican or Democratic status. You will see that about 75% of the respondents questioned whether Barack Obama was a citizen. Some said they weren't sure, and others, or was born in the United States, that is eligible to be president. Some said they weren't sure, and others said he wasn't. But added up together, those two groups are close to 75%. That's just shocking, right? That's just amazing that such a significant number questioned the citizenship of the man who'd been president for 8 years and his eligibility to be president. And it shows me that this phenomenon was more significant than I realized at the time. So why don't I stop the share? I can go back if someone wants to see a slide and just see if there's any questions or comments about anything I've said or that modern era.
Well, we've got a couple. And I think that Pam's question has to do with the respondents to that poll. She asks, do you have a breakdown that would compare college-educated respondents versus non-college educated respondents?
Yeah, I don't, and that's an interesting question. I will say this, I could look into that because I'm interested in that too. I will say I've seen data that says that many of these sorts of beliefs are not based on attending college or not. Because then you could say, well, we just need to educate people more, right? And if they're educated, they will see the world as I see the world, which is how can you question Obama's citizenship when the man produced his long form birth certificate, which is more than anyone else has ever done. And there's lots of other evidence. I think it might be more complicated than just, well, if we, people were educated, they wouldn't believe these things. I've seen some data to suggest it doesn't divide along the college non-educated, college non-college line. That said, I'm not certain, so I could look back, and it's a good question. I'm going to make a note to look at that for future. Thank you.
That's a great question.
Yeah.
James would like to know the name of the author that you referenced pertaining to Native American citizenship.
Sure, it's Bethany Berger, and her last name is Berger. If you want to email me after, feel free. My email is afrost@american.edu, and you can also just find me really, really easily. Amanda Frost. So I'm happy to send you the link to our article, which is publicly available. And it's an article that actually compares the Wong Kim Ark case that I mentioned involving Native American citizenship. And it's very well written and accessible and interesting. I don't know if James is a lawyer or law professor, but you don't need to be to read it. So, and it's a good read. And I have to say, Bethany was very, very generous with her time with me. So I'm delighted to refer people to her excellent scholarship. And her scholarship sites and other work as well, if you want to go from there and read other work on Native American citizenship.
That's a great question. Thank you, James.
Yeah.
Gail asked, what happened in the Supreme Court case where Roberts asked the question?
Great. So that's a great, so that case was Maslin Jack. I don't remember that. I think it was versus United States. And Roberts asked that question. It was one of those moments when I listened to the oral argument. I didn't attend that one. I actually quite often attend. They're great entertainment. And get the, well, and you also can see who's going to win or lose often. And you could see the government lost its case right there and then. Because Chief Justice Roberts asked this question. And I should clarify, not to get too technical, but there's two types of denaturalization. There's a criminal case where you can actually prosecute the individual as well as denaturalize them. And there's civil denaturalization. Criminal, both cases were brought against Harry Bridges, who I mentioned before. So criminal denaturalization, that was the issue in Maslin Jack. And that's the case where the government said we could denaturalize and bring criminal charges against anyone, including someone who'd driven a few miles over the speed limit, was never stopped, and failed to note that on their denaturalization application. So Roberts asked the question, the Solicitor General answers, yes, we could denaturalize someone and criminally prosecute them for that. You could see the government lost its case right then. They lost 9-0. But that was a case about criminal denaturalization, and civil denaturalization. It's clear the government still thinks it can denaturalize for errors on an application, such as those kinds of minor errors. They've gone after people for things like typos. So yes, the Supreme Court ruled against the government in that criminal case, But civil denaturalization still seems to be, the grounds for it seem to be very broad indeed.
Well, I have a question for you too, which is, so in not all cases where someone had their citizenship stripped, they don't always result in a deportation. So if someone is a non-citizen, then are they functionally rendered stateless because they're not necessarily a citizen of some other place?
Yes. So in fact, that's a really interesting point. Europe has actually enacted, some countries in Europe have enacted laws allowing denaturalization of terrorists. The United States has not done this. And this is recent, current law. And they actually limit that to people who have another citizenship because they recognize the problem of statelessness. The US doesn't have an easy answer to that. Parvez Khan, the man whose trial I saw, he lost his citizenship, US citizenship. So the next question is, what happens to him next? And you ask a really good question. Could he be deported? Well, he could be. It couldn't happen immediately. He'd have to lose his green card, but the very ground on which he lost his citizenship would suggest he should also lose his green card. So that would be a legal process in an immigration court. And then he could be deported. Well, what if, I think he was from Pakistan. What if Pakistan didn't want him back? He could be detained for months on end while the United States tries to find another country that could take him. The consequences for him are very, very serious. Now, it's not clear the government will deport him. But then the next question is, why are we spending hundreds of thousands of taxpayer dollars to take away the citizenship of a man with no criminal record, with US citizen wife and spouse, just to then call it a day? Like, in some ways, if they don't deport him, it makes it even more bizarre that they spend time and money on this. Yeah.
Yeah, really, really interesting stuff for sure.
Yeah.
And so Pat has kind of a two-part question, one related to the other. So the first question is on the question of former President Obama's citizenship. So the fact that his mother was a United States citizen renders him a citizen. And I think Pat is trying to clarify, just if someone is born to a US citizen outside the United States, you're still a citizen, even if you're not born in the United States. And then the follow-up is it true that there is no other country that recognizes birthright citizenship? Or was that a misunderstanding on the part of former President Trump?
Yeah. All right. So the first part of that question, I want to say it's actually not true that if you're born outside of the United States to a US citizen parent, you're automatically always a citizen. The parent has to have lived for a long enough time in the United States. Right now it's 5 years with 2 years over 14. And I think when Obama was born, it was longer than that. And his mother was very young when he was born, as many know. I think she was 18. So if he had been born outside of the United States, he might not have been a citizen. I haven't looked into it. He was born in the United States.
Right.
No question. So really, that's the end of the story. He was born in Hawaii, which was part of the United States, and he has a birth certificate and much other evidence to prove it. But in fact, it's interesting. You don't automatically inherit citizenship from a US citizen parent. The idea is if your parent barely lived in the US, they haven't really transferred to you all of the cultural attributes of citizenship, which is why the law right now requires at least 2 years over the age of 14 that you have to live in the United States before your child will also be a citizen if they're born outside the US. And I'm sorry, what was the second part?
Oh, sure. Is it true that the United States is the only country that recognizes birthright citizenship?
So I'm glad you asked that because, Trump, obviously, you could, he tapped into a lot of things. He often said things that were like on the verge of correct. I mean, he said things that were just completely false. Mm-hmm. Birthright citizenship is the way the US has it, a very pure birthright citizenship regime. A child born in the US who leaves the next hour is a US citizen for life. The United States is very unusual in that. Now, it used to be the case that Europe had that rule, but most European countries have abandoned it, including France, where I'm in right now, and the United Kingdom. So it is true the US is unusual. Some countries in South and Central America have similar rules. But as Eric Foner has said, the great historian of the Reconstruction era, this is American exceptionalism at its best. And in fact, my next book is going to be on birthright citizenship. I think as a country of immigrants and a country that had to overcome its legacy of slavery, unquestioned, pure, unlimited birthright citizenship is very important to creating the casteless society that we have today. And I think there's reasons France and England have abandoned it that are appropriate for those countries. The US, I think, birthright citizenship is part of who we are. You're born in the USA, you're American, period.
So there's no other countries, any place in the world
No,
that
sorry.
have that?
Well,
I'm curious about that too.
Yeah, no, there's countries, and so we're unusual for, often we compare ourselves to Europe, right? And we have some Europe. There are some countries, and I don't know the names, in South America that have similar citizenship rules. And in fact, there's a great, I'm happy to send it to people, website, Global Cit, which is a global citizen, short for global citizen, that does research on the citizenships rules of each country. And you could look there. A lot of countries have birthright citizenship with a qualification. So in other words, in France, if you're born in France to non-citizen parents and you remain in France till you're 18. So that's not the US rule. The US rule is pure birthright citizenship. France comes pretty close, right? Because the idea is regardless of your parents' status, undocumented immigrants or not, or whoever, you're a citizen if you're born in France and stay. But they're just not willing to give citizenship to someone who's born to non-citizen parents who leaves. So I'm not saying no other country has birthright citizenship in some way, shape, or form. Many do. The US is quite unusual in its pure form of birthright citizenship.
That's great. Well, thank you so much. I could ask you questions for the rest of the evening, but it's already past midnight your time. And we really appreciate you having joined us for such a long time tonight. So I'll just let everyone who's here know that Dr. Frost's book, that You Are Not American, is available at the Montpelier shop. So you can get it elsewhere, but you can also get it at the Montpelier shop. So use your member discount, always a good thing. And it's just really, really fascinating. So I certainly encourage you to pick it up and read it as wherever you're able to lay hands on it.
And I'll just say quickly, I want to say quickly to this group that I'm very happy to do book groups, especially because it's so easy to jump to appear. So if anyone's interested in doing a book club with my book and you want me to come and chat for 10, 20 minutes with your group, I'm happy to do that.
That is an incredibly generous offer. Well, and I would also then say, if you don't mind, Dr. Frost, sending me those couple of references, and then we can include the references with the copy of tonight's video. And then folks can follow up on some of those other questions that they may want to explore further, because just questions of citizenship are super, super interesting. And I am very appreciative of your time spent with us this evening to kind of explore that at large. So thank you so much. And
thank you.
Enjoy the rest of your time over in France.
I will. And thank you. And thank you to the great questions from the audience. I appreciate the invitation and being able to interact. So thank you.
Wonderful. All right. Good night, everybody. Thank you.